All right, all right, all right. It looks like we are live. Late, but live. That's all right. Hello, welcome back to the BRI-HIVE. For those of you who do not know who I am Boss Attorney Bri, and I am a licensed attorney in California where I practice family law and trademark law. And here on this YouTube channel, we cover trademark lawsuits, copyright lawsuits, celebrity lawsuits, and really whatever we feel like covering. And today we are doing a crossover. We've been having a lot of crossovers lately. A lot of crossovers. So we are doing a crossover of celebrity and lawsuit. We are doing celebrity and trademark. And then we have another trademark lawsuit. But would you consider like Skittles brand, the Mars company, would you consider them as being a celebrity since the candy is so popular? In my opinion, it's popular. I think a lot of people know about the Skittles, but maybe not necessarily the actual company's name. So let's see who is alive with us today. I lost my mouse here, so let's find that. Oh, it's weird shadows today. Sorry, guys. Sorry for the lighting. It's kind of gloomy outside today, but let me know how you guys are doing. Go ahead and drop it in the chat if you're watching live. If you're watching on the replay, go ahead and let me know how you're doing as well. I am going to get into the chats, see what's going on, because we got a lot to cover today. And I've had a pretty busy day. That's why I was late. So we're going to keep having a busy day as we go on. So let's see. We have MB Gerald saying interesting to the case topics. I'm assuming early comment. We have Marianne Williams. Welcome back to the live stream saying hello all and giving us a BRI-HIVE emoji. We have Jessica Otterson saying hi to everyone. Z Seltzer says hi from Cleveland. Nice to have you back here, Z Seltzer. We have Deacon Fatal, a member and moderator of the channel, saying hello all. Skittles. Well, this is new. Well, it's about to be old because they're already settling the case. This was a pretty short-lived case. Okay. And then we have Marianne Williams, a new member of the channel, saying, I hadn't heard of the Skittles trademark lawsuit. I only heard about a lawsuit filed against Skittles for being toxic. Yeah, when I was pulling up this case, they have a lot of personal injury cases going on. Not a lot of trademarks, so it was easy to find this trademark case. But yes, I don't know about that toxic case, but you probably are right in that they have a lot of personal injury cases. And if they are toxic, likely to be a personal injuries case or a products liability case. But yeah, they had a lot of lawsuits. As far as personal injury goes, we have Hella Swanky, a moderator and member of the channel, saying, hi, BRI-HIVE. I hope everyone is well. Yes, exactly. I hope everyone is doing good. Daz Beat says, hello, all. Hello, and welcome back to the channel. We have Carolina Diaz saying, hello, hello. Welcome to the channel. We have Tamara Marie saying, hello, I'm new, excited to catch you live. Well, welcome here to the live stream. We are going to get into some crazy trademark stuff, which a lot of the lawyers on YouTube don't cover. So I am happy to give you guys a taste of what's going on in the trademark world. And honestly, both of these are trademark cases. Like, I tried to search celebrity lawsuits, and for those of you that watch me on a regular basis, you know there's always a plethora of lawsuits coming in for celebrities, but today not so much. But I found a couple of things on trademarks today, and so that's what we're covering. And I think it's going to be pretty interesting. We have Jennifer Connolly coming from Connecticut. Welcome to the live stream. We have Judy, you got this, or yeah, that's her name. Judy, you got this, saying live for once. Yay, yay. Welcome to the live. We're happy to have you here. I was running a little bit late, but that's okay. We're here. We're here now. We have Carolina Diaz from Georgia. Hello. Welcome from Georgia. We have Judy, you got this, from Arizona. Welcome from Arizona. We have Betsy coming from Michigan. Welcome, welcome. We got the emojis going on. Love to see it. We got Not That Karen. I like that name. I like that name. Not that kind of Karen, right? Okay, saying so happy to catch live streaming. Hello from Kansas City. I'm going to go with Kansas City. Welcome to the live stream. We have Livia saying hi from Ontario, Canada. Welcome from Canada. So far, well, yeah. So far away, but welcome from Canada. Where are we at? Okay. First time watching your live. Well, thank you for joining us live. I hope you find it as interesting as the replay. We have Jane Stoddart saying hello, Bri and BRI-HIVE. Oprah is suing. So exciting. Yeah, she's suing a podcast, which I think they talk pretty positively about Oprah, but she's still suing them, or her companies are suing them, right? Sage Moon says, hey, everyone, welcome back to the live channel, saying so many folks out here infringing on other trademarks. It has got to be something in the water or something. But yeah, we're going to get into what's going on here. Jane is also from rural Ontario. Well, welcome to the live stream from Canada. We got the Canada peoples here today. And we have Sage Moon saying hello to Hella Swinky. How are you? Hope you're doing well. I hope everyone in the live stream is doing well. I always feel like when I come on here on Tuesday, I'm like, oh, I'm happy the week is almost over. And the reality of it is that the week just started. So that's a little bit depressing, but the time goes by so fast. So I guess it's not all the way depressing. I guess it's just like kind of depressing, right? Okay, so do you guys have a preference in what case we start with? Are you looking forward to Oprah Winfrey, or are you looking forward for Skittles? So remember, Skittles, they're at the end of the lawsuit. We did not go through the complaint on this channel. I did see it a while back, but we didn't happen to cover it. And so we're going to be going on over their judgment that the defendants actually agreed to, of what they're finding as trademark infringement, and the fact that they're going to have to stop using the similar trademark. And remember, the Skittles case, or not remember, I didn't really introduce the case all the way. The Skittles case is I keep calling it the Skittles case, but the company is called like Mars or something like that. They sued some CBD and THC companies, so marijuana companies, for basically making products similar to Skittles and other famous candies that Mars sells. Oprah, on the other hand, is suing a podcast called Oprahdemics for basically using a confusingly similar name as her, and basically making people believe that Oprah is sponsoring this podcast. So I'm going to see what the chat says. Which one would you like to cover? We know we love candy over here on the, well, I love candy at least. I don't know if the BRI-HIVE love candies, but I definitely love sweets. So I'm interested in checking out the judgment, and then we can go into the complaint for Oprah Winfrey. But I'm waiting to see if we get some more comments coming in. We have, let's go see, we have Cass. Hello, welcome back to the live stream, saying hi. It's my birthday today. Happy birthday. Yay. Let us know how old you're turning if you want to. The chat always gets on me for my young age, but I don't know if anyone knows my real actual age. But happy birthday, happy birthday. So I'm only passing by to say hi and do the YouTubey things. Well, thank you. Yes, guys, if you have not already, and you're watching live or on the replay, go ahead and hit the thumbs up button to help us out in the algorithm. If you're not subscribed, go ahead and subscribe. Your subscribe button should be gray and not red if you really love the channel. And what else can you do? You can also join as a channel member. If you want to support the channel monetarily, it's $5 a month. You get cool emojis and cool little badges next to your name, your legal badges next to your name. For those of us that have not gone to law school, we can still get our legal badges. And it really supports the channel, and I definitely appreciate it. And your name is highlighted for me, so it's easier for me to catch your comments. I know right now I'm going through more people's comments because our chat is not as fast as some of the cool big YouTubers. So I pretty much get to everyone's comment now, but as the channel grow, I may not be able to get to the comments as fast. And the highlighted green ones do stick out a little bit more. So just going through the comments here. Betsy saying heart to CA. We have Libby saying Skittles, please. Okay, we got one vote for Skittles. We got another vote from Marianne for Skittles. We got Betsy with Skittles. Betsy said vote. Yes, question mark. Yeah, I probably should have put it as a poll, but I was too busy running my mouth. Carolina Diaz says Skittles. Okay, I think we're going Skittles. Go for the candy first. Yes. And Lisa McKinnon says, what have I missed? Skittles sounds interesting. Yeah. You just missed the introduction. We are just getting started today because Bri was running late on a client call. So we're just now getting started. So you have not missed much. Okay. I see a comment coming in on YouTube Studio. It's not on StreamYard yet, saying dessert first. Here it is. Judy, you got this, says dessert first. And I have definitely ate my dessert first. I had cookies just a couple of minutes ago, and I still need to cook later, and I need to go to the gym. So cookies probably was not a good idea. All right, we're going to jump right into the case because, like I said, I still have a busy day after this. So I want to cover everything here and then get on with my day. So I don't think we're going to be live streaming for 2 hours today, but we'll see how the chat goes. You know how I get distracted, okay? So let's see here. We have this case filed in the Central District of California. Can you guys see that? It's W.M. Wrigley Jr. Company, which is that Mars company I was talking about that sells Skittles. And they sued Roberto Conde, DBA 2020 Edibles. So it looks like they started in 2020. Joel Ledesma, DBA Inland Empire 420 Supply. And remember, guys, these are THC companies, so you're going to see similar names to reference the CBD, or not the CBD, THC companies, otherwise known as marijuana. I don't know if I could say that on YouTube or if they're going to ding me for that. Jessica Moore is the individual. Stephen Matta, doing business as OC 420 Collectibles. I can't believe all these people are doing business as, like, they're literally running their company under a sole proprietorship, but they're selling weed. That is not a good business idea. Okay. Maybe they can't get an LLC for it. I don't really work with CBD, or not CBD. I keep saying CBD, with cannabis companies. Maybe that's a better word. Cannabis companies. But I don't see how being a sole proprietorship would be a good idea in such a what word am I looking for? I want to say a liability, but I can say that, high liability industry. So I'm really surprised that they're doing it as a sole proprietorship. Okay. And so who else do they have? They have Doe 1 doing business as Gas Buds, Doe 2 doing business as Cannabis 420 Supply, and Doe 3 through 10, just in case they miss whoever it is. Okay. Oh, my grandma's calling me during my live stream. I haven't talked to her in a while and I want to answer it, but I can't because I'm live streaming. Okay. This is the final judgment by consent under Rule 454B, including permanent injunctive relief regarding defendant Steve Matta doing business as 420 Collection, or OC 420 Collection. And so this is the ruling. Some of these defendants did not answer the complaint, so some of them had a default entered against them, and it looks like this guy, Stephen Matta actually just agreed to say, hey, you know what, I infringed, let it go, right? The other companies, they did get defaults filed against them, and I believe they also had it entered against them. So let's check out what the complaint is actually, or not the complaint. This is a judgment. We are at the end of the lawsuit for once. It says, this matter having come before the court for the entry of final judgment against defendant Stephen Matta, doing business as OC 420 Collection, the correct spelling, with the consent of plaintiff W.M. Wrigley Jr. Company and Matta, collectively referred to as the parties, in accordance with Rule 54B of the Federal Rules of Civil Procedure. It is ordered, adjudged, and decreed. So they're agreeing to this judgment. They're not going to trial over it. He's not fighting whether it's infringement or not. They're basically coming to an agreement that it is actually infringement, which is probably smart for him to do. Just that company is going to have a lot of money to fight them. He is literally an individual doing business as a CBD company, which is a high liability company. It really just became legal. So I don't know who these people's lawyers are. I might want to do more research into that. Like, why are they putting personal liability on themselves for such a high liability company? So basically, when you're a sole proprietorship and someone sues you, you're liable personally and individually for anything that your company does. So if he owns a house, they can come after it. If he was just like a corporation or something like that and he did something bad, it would just be the corporation that is liable as long as he did not pierce the corporate veil and was acting as an individual under the corporation. So he's getting sued. His house can be on the line. His car can be on the line. But if he was a corporation, it would just be his business assets. So whatever he has in the bank account and things like that. So this could be another reason why he went ahead and agreed to this. Okay. Let's see, where are we at here? I'm trying to get to the chat because I see something. I can't see the one that Tanya put that is the 3 months. It's not showing me the 3 months on StreamYard, but Tanya D, moderator of the channel, and is now a 3-month member of the channel. So a new badge, I think, should be coming unlocked for you. Thank you so much for supporting the channel. You're always here live. You're always here helping out the chat. So we definitely appreciate you over here at the BRI-HIVE. Say congratulations to Tanya for being a member for 3 months now. One of the longest members in the community. Thank you so much for supporting the channel. Let's pop back over to the judgment here and see what they have agreed to. Matter has been properly served. They consent to the jurisdiction and the venue. The court has subject matter, jurisdiction, all the boring legal stuff. The parties agree to submit to the jurisdiction of this court and enforce the provisions of this stipulation and final judgment by consent worldwide. Let's get to the stuff because they're just saying who these people are. Wrigley is a recognized global leader in confections and together with its affiliates offers a wide range of product offerings including gum, mints, and candies. Wrigley markets products under dozens of well-known, distinctive, and famous brands including Skittles, which is registered, Starburst, Lifesavers, Double Mint, and Juicy Fruits, to name a few. Let me know if you knew that all of these candies were owned by the same company. Go ahead and drop in the chat whether you knew they were all owned by the same company. Okay, we have Wrigley and its predecessors have long marketed candy and related products under the famous Skittle mark and trade dress, which features, among other things, the word Skittles in white block letters, distinctive rainbow design, distinctive candy-coated lentils. That's what it's called. It's called a lentil? Interesting. With the S imprinted thereon, and a cascade design of these candy lentils, herein referred as Skittles trade dress. So here's the picture of the Skittles product. And you know what's kind of funny? They really do print on each, and well, I don't know how Skittles work, but for those of you that watch the Emily D. Baker and Natalie live stream that I was on Emily D. Baker's channel, you know that I used to work at Jelly Belly. If you watch that part, you would know that I used to work at Jelly Belly, and they really do have a little printer that prints these tiny little words on these tiny little candies. I'm pretty sure Skittles has something similar, but it's very interesting to watch. It prints multiple at a time, but it's crazy. Who had the idea to put such small letters on candy? It's right. It's crazy. Literally crazy how they do it. Okay, here are Skittles. Hope it's not making anybody hungry. They even got some zombie Skittles. Perfect time for, Halloween coming up. I don't know if you guys are like people that I know, and they go ahead and get started on the holidays very, very early. Alpha is already saying that he wants to put the Christmas tree up. And I don't even think he celebrated Christmas before you met me. But he wants to put the Christmas tree up. And yeah, people get started with Halloween in July, like my sister. So let me know if you guys like holidays, like my family like holidays. Okay, here we go. For 50 years, Wrigley and its predecessors and interests have continuously used Skittles mark to advertise, promote, and sell candies throughout the United States. Wrigley has earned billions of dollars in revenue from the sale of Skittles candies in the United States. Many millions of people throughout the country have purchased or consumed Skittles candy. That is true. I have had Skittles several times. But who said that they were toxic for other lawsuits, right? In fact, Skittles candy has been the best-selling non-chocolate candy in the United States for years. And this guy is agreeing to all of this, okay? Wrigley has invested many, and you can tell that Skittles, the owner of Skittles, their lawyer is probably the one that wrote this agreement, okay? Because they're hyping Skittles up, and this guy just signed it off and agreed to it. Wrigley has invested many millions of dollars to promote Skittles candies. Wrigley's advertisement and commercial for Skittles have been seen by millions of people nationwide. Wrigley advertises Skittle candies during the Super Bowl and other highly watched events. They are really going in on how famous their trademark is. Based on the widespread and long-standing use and recognition of the Skittles brand, Wrigley enjoys extensive trademark rights in the Skittles mark and the Skittles trade dress. Wrigley owns numerous federal registrations for its Skittles mark and the Skittles trade dress, including but not limited to all of these registration numbers that we're not going to read out loud. They're calling them all the trademark and trade dress. Similarly, Wrigley and its predecessors have long marketed candy and related products under the famous Starburst mark and trade dress, which features, among other things, the word Starburst in stylized lettering and distinctive wrapper with the S imprinted thereon. They have it. Oh, on the wrapper. Okay, I'm like, they don't have an S on the actual candy. If they do, I missed it several times. For 50 years, Wrigley and its predecessors and interests have continuously used the Starburst mark to advertise, promote, and sell candy. Wrigley has earned billions of dollars in revenues for the sale of Starburst. Many millions of people throughout the country have purchased and consumed Starburst. Wrigley has invested many of millions of dollars to promote Starburst candy. Wrigley's advertisements and commercial for Starburst have been seen by many of millions of people. Based on the widespread and long-standing use of recognition of the Starburst brand, Wrigley enjoys extensive trademark rights in the Starburst mark and the Starburst trade dress. They didn't say that they market this one at the Super Bowl. So have you guys ever seen a Starburst commercial at the Super Bowl? They have all of these federal registrations that we are not going to list for the Starburst. Each of the above referenced trademark registrations are valid, subsisting, and in full force under the trademark statute, and together with Wrigley's extensive common law rights, makes the Skittles mark and trade dress and Starburst mark and trade dress valuable assets owned by Wrigley. Basically, they are just trying to establish the fact that they are that they have protection in their trademark. Not only do they have a registration, but they are also so famous that any use of their name, people are going to recognize it as coming from them and as them promoting it. And as a candy company, they don't want people promoting their name or promoting their product that contain technically drugs in it. When candy is sold to people of all ages, you don't want to be selling drugs to kids and things like that. You don't want kids to get confused if their aunt or someone brings in the cannabis candy and they see Starburst or Skittles and they eat it. And then all of a sudden we have a little kid that has just done cannabis because they thought it was Skittles. And then they ate the whole bag. That's dangerous. They do not want to be liable for that. So it makes a lot of sense. It makes a lot of sense. Okay. Let's see where we're at here. Meta doing business, and they're going to let us know a little bit about the person being sued. Meta doing business as OC420 is engaged in the marketing, offering for sale, and distribution of edible cannabis candy products. Meta, we'll go with Meta, used the Wrigley trademarks without authorization or license in the marketing of his products. He admitted to this. I would have just said, I'm not admitting, confirming, or denying. I'll just stop selling it. But he admitted to actually using it, okay? Or, selling under their name. Specifically, Meta has marketed, offered for sale, sold, and distributed products online via OC420 website, which violates Wrigley's rights in the Wrigley trademarks. Those products include medicated Skittles, what a name, sold in 4 flavors: original, sour, wild berry, and Seattle mix. So he went above and beyond on this. Different flavors, right? And what else does he sell? Medicated Cannabis, which is, I guess, the alternative to the Starburst is the Cannabis gummies, sold in 3 flavors: original sours, berry sours, and tropical, and 3 Munchie Edibles deals, which includes a package of Cannabis gummies. These products, collectively referred to as OC420 infringing products, are pictured below as they appear on OC420's website. So let's go ahead and check out what their products look like. Medicated Skittles. That looks exactly like Skittles. Let me make this bigger for you guys. I did not look at this, as you guys know, before I got on the live stream, because one, I like to live react, and 2, a lot of times I don't have time to look at this stuff before I get on here because I work a full-time day with my law firm. So look at this. This looks exactly like Skittles. If I was a little kid and I saw that, I would think that it's Skittles. I don't know why StreamYard does not give me the member chats of when you guys are you have the membership celebration, but we have one from Who Said K says, not a chocolate fan, but loves Skittles with a blue heart. And Who Said K has also been a member for 3 months. Again, thank you for supporting the channel. I definitely always appreciate it. Who Said K is also a moderator of the channel and a longtime member of the channel, and is always here helping out, always here on the live stream. So I definitely appreciate your help. I'm sorry I cannot show your chat here, but it doesn't pop up on StreamYard, so I can't pull it onto the screen. But thank you nonetheless for being a member for 3 months and supporting the channel. What do you guys think about this Skittles here? Skittles packaging. Can you guys see the little cannabis leaves on it? I don't know if it's too little. I think you guys can see it, the little green cannabis leaves there. Yeah, so that's how they're selling their medicated Skittles. A child can definitely eat that and think that it is, Skittles. Starburst, Cannabis looks exactly the same as Starburst as well. Same yellow, the little squares, all of the things, right? $12 Starburst. They got different flavors down below, and it's called Medicated Cannabis Gummies. And then we have this little deal. They got hot Cheetos too. Flamin' Hot Runts, I think it's called. Cannabis gummies. They also sell Gushers. They also sell Nerds. They basically just stole all the popular candies' names. You cannot do that. You definitely cannot do that. They stole, I'm surprised that they're the only ones suing them, because they're using a lot of famous brands. A lot of, they're calling this a Nerds rope. That's an actual candy by Nerds, the rope. I remember I used to love those. Okay, so what do you guys think about that? What do you guys think about that? Okay, let's see what else they have to say here. With respect to the Skittles mark and trade dress, Meta adopted and used the Skittles mark in plain text and in white block lettering, distinctive rainbow design image of the candy-coated lentils. I didn't know that Skittles were called lentils. I always thought lentils were beans. I think lentils are beans. I don't know. I don't know. Okay. With the S imprinted thereon, and or design featuring such candy lentils cascading along and upside down rainbow marks and trade dress that are identical to, substantially indistinguishable from, and or imitation of Skittles mark and trade dress and the marks and logos in the Skittles registration. With respect to Starburst mark and trade dress, Meta adopted and used the Cannabis mark with stylized lettering and images of square candies with stylized S imprinted thereon, marks and trade dress that are identical to, substantially indistinguishable from, and or imitations of Starbucks trademark and trade dress. Meta took such action with full knowledge of and in willful disregard of Wrigley's intellectual property rights, and with the intent to take advantage of the goodwill of Wrigley has developed in the Wrigley trademark. Mattis complained of acts above constitute the following. He agreed to all of this. counterfeiting the Wrigley trademark in violation of section 15 USC 1114. Wrigley infringement of Wrigley's trademark in violation of another trademark statute, dilution of the inherently distinctive and famous Wrigley trademark, unfair competition and deceptive acts and practices in violation of the Trademark Act, unlawful, unfair, and or fraudulent acts of business practices, including unfair, deceptive, untrue, and misleading advertisement in violation of settlement business or California Business and Professions Code. He should have just settled. He should have just settled, and then this will not be in writing, and he should not have admitted to violating it. Unless Wrigley was like, no, we're not settling. You have to admit that you violated, or we're going to trial. I guess that could have been an option. Unfair competition and deceptive acts and practices in violation of common law. This is an acceptable case in accordance with the trademark law. Matta, in his capacity both as an individual, again, remember he's a sole proprietorship, and as a proprietor of OC 420 and its respective officers, agents, servants, employees, successors, assigns, attorneys, and all other persons acting in concert or in participation with or affiliated with Matta and or OC 420 jointly and severably are permanently enjoined and restrained from directly or indirectly engaging in any further trademark counterfeiting, trademark infringement, trademark dilution, unfair competition, or deceptive business practices related to Wrigley trademark, including the Skittles mark and trade dress and the Starburst mark and trade dress and any other trademark or trade dress owned by Wrigley. From making, manufacturing, advertising, marketing, offering, selling, or distributing any products that feature, copy, imitate, simulate, or are confusingly similar to or likely to dilute the distinctive nature of or tarnish the goodwill of Wrigley trademarks, including Skittles and Starbucks or any other marks owned by Wrigley. They are enjoined and restrained from representing by any means whatsoever, directly or indirectly, that any product sold or services rendered rendered by Matta and or OC 420 are associated with, sponsored by, licensed by, and or connected or affiliated with Wrigley, or from otherwise taking any action likely to cause confusion, mistake, or deception on the part of purchasers as to the origin or licensing of Matta and the OC 420's product or services, from otherwise competing unfairly with Wrigley in any matter or engaging in deceptive conduct, from continuing to perform in any manner whatsoever any of the acts complained in the complaint as to Wrigley, and from causing, engaging in, or permitting others to do any of the aforesaid acts. Within 30 days of the entry of this final judgment, Matta shall file with the court and serve on counsel for Wrigley a sworn written statement as provided in the statute, setting forth is detail the manner and form in which Matta, in his capacity as an individual and as the proprietor of OC 420, has complied with the permanent injunction. Matta, in his capacity as an individual and as a proprietor of OC 420, shall immediately recall from all distribution channels any products, packaging, advertising, or promotional material bearing or infringing on Wrigley trademarks, including Skittles and Skittles and Starbucks trademarks and trade dress. Matta, in his capacity as individual and proprietor, shall immediately deliver to Wrigley counsel for destruction any product, packaging, advertising, and promotional material bearing or infringing on the Wrigley trademarks, including Skittles mark and trade dress, Skittle and Starbucks marks and trade dress, and other trademark dress owned by Wrigley. Any electronic equivalents of such material. Yeah, and usually when you are making these type of products, you're hiring someone to do the packaging for you. So I wonder who made this packaging for him. Like, if we're printing companies, you can't be helping people violate trademark law just because you want to make a couple of dollars on printing packages for someone. Same thing. Well, I guess he might be actually making the candy, but yeah, you don't want to do that. You don't want to assist them. Back to the judgment. Meta, in his capacity as himself and for OC 420, shall immediately cease sales of the product described on the OC 420 website and in any other location on the internet, including other websites owned or operated by Meta and or any of his affiliates, and any social media platforms owned by Meta or his affiliates. Meta shall immediately account for and disgorge to Wrigley all profits, not a percentage, all profits wrongfully derived by his unlawful conduct and paid to Wrigley. So that quick money that he made off of these Skittles and Starbucks, not, why do I keep saying Starbucks? These Skittle and Starburst candies, he has to pay back to Wrigley, this big giant company that had no hand in making these products, who had no hand, I guess, partly a hand in marketing the products because they were able to use their famous trademark, but they get all the profits from it. He's gonna have to make some new candies or something. I don't know. Yeah, but he can't sell it no more, and he got to give all the profits to Wrigley. Okay. All monetary, they have to return all monetary, actual, and statutory damages sustained and to be sustained by Wrigley as a consequence of Meta unlawful conduct, including without limitation statutory damages and the amount of $2 million per counterfeit mark per good sold, offered for sale, or distributed pursuant the trademark statute, lost profits, incorrective advertisement. Wait. Oh, $2 million per counterfeit mark per type of goods sold. Okay. So they had 4 flavors of the Skittles and 3 flavors of the Starburst. So 7 times 2 million. Is that what they're asking for? They should be more clear. So they're asking this guy for $14 million from what I understand from that. All profits gained and advantages obtained by Meta from his unlawful conduct, exemplary damages, including treble damages resulting from Meta's unlawful conduct, prejudgment interest on all damages, and Wrigley's cost and disbursement in this action, including its reasonable attorney's fees. Meta's wrongful conduct is deemed to be willful and malicious, and this judgment is therefore non-dischargeable in the event that he files bankruptcy. Yeah, so Dabs B says, sounds like bankruptcy. Yeah, but they just said it for us. Where did it go? His conduct is deemed to be willful and malicious, and this judgment, therefore, is non-dischargeable, which means even if he files for bankruptcy, he still has to pay it. Why did he not go for a settlement or not answer like the other people? Well, no, if you don't answer, you can still get something like that. Ooh, I should download the default ones too to see what they have to pay. But that's whatever he sold, however much money he made from selling it, plus $2 million per infringing mark. Are we talking about per unit? Because we don't know how many he produced and sold. But I'm going to go with the safe bet and say 14 million is what they're asking for. Basically, they don't want him to be able to be like, okay, I paid off Wrigley. Let me just sell some other candies and I'm just not going to market them as Skittles or whatever, and I can still make money. They're trying to put him out of business. Or he stays in business and sells other things, but he's paying off Wrigley for the rest of his life. For the rest of his life. Unless cannabis businesses are making that much money. Are they making $14 million a year? I don't know. Maybe the illegal businesses, but like the storefront businesses, I don't know. I don't think so. Maybe. I also don't use that, so I wouldn't know. So yeah, I don't know how much they could possibly be making. Parties shall comply with the terms and of The parties shall comply with the terms of the confidential settlement agreement entered into by and between parties and executed concurrently with their stipulation to the final judgment by consent, the terms of which are incorporated herein by reference. The final judgment by consent shall have no effect on any of Wrigley's claims against other defendants to the action besides Mata. Notwithstanding the foregoing, the court shall retain jurisdiction over this action as it relates to Mata to enforce the final judgment by consent and the terms of settlement agreement. Who is his lawyer? They made an example out of him. Some of the defendants did not respond. Other defendants, the case is still going on against them because their attorney probably told them, one, not to admit to it because he's paying $14 million in my calculation. I don't know what calculation they have going on, but he's paying $14 million because he admitted to it being willful and malicious, and now they get statutory damages and they also get his profits. It doesn't look like they got attorney's fees. They might not have asked for that, but that's a lot of money. That's a lot of money, even if it's just $2 million. But I'm pretty sure I read that right in the per unit. And if they talk about per unit and the amount of I'll have to double check the statute of what that refers to, but per unit as in how many bags they actually created. Woo, no. Let's see what the chat has to say about this. We have Marianne Williams saying, I'd have to sue too. They had to sue. I'm surprised no other companies did sue him in particular. But remember, there's like 6 other defendants here that are doing the same thing. Who said Kate says very irresponsible? Absolutely. Judy, you got this, says, if I were in a hurry, I wouldn't think twice about grabbing an edible when I only wanted candy. And then you would be driving down the street on cannabis. And that's not safe. And it's really not safe. It looked so much alike. Like, let's go back to it. You can barely tell the difference. And like, okay, you might know that you're on a cannabis website, but at the same time, if someone just has it in their house, like, man, you will be high, not even on purpose. Like, you're not even high on purpose, man. So yeah, they basically copied the entire thing. They got the little calorie thing all in the same section. The fact that Skittles or Wrigley sells these shareable bags, like, it looks exactly like, well, they didn't put the shareable bags that they have on there, but yeah, like, even the little calorie sign is similar. Like, you would think that it's candy. You would think that that's candy. I mean, it is candy, but you wouldn't think that it has cannabis in it. Okay. So Rose says, so much audacity. Absolutely. Dasby says, they're lucky all those brands are owned by the same company. Not all of them. Not all of them. They didn't sue. Some of them are owned by different companies. Otherwise, they probably would have listed those as well. Judy, you got this, says, I think lentils refer to the shape of the candy. That probably, yeah, that makes sense. Lisa McKinnon says, it sounds like the person getting sued should have hired an attorney a long time before marketing began. Absolutely correct. Absolutely correct. And that's why we talk about trademark. Whenever you guys are starting a business, you want to make sure you're not infringing on someone else's trademark. And just because you make it into a weed product does not mean you are not infringing on the other person's. Like, this should not have even been an idea that came to his mind. And you know what? He's not even that bad, because like I said, there's 6 other people that's being sued for the same thing with him in this lawsuit. So yeah, you can't do that. But they probably saw other people doing it and decided they were going to do it too. Judy got this, says, Lisa, I agree. Marianne says Lisa's right. Tiny D says definitely Lisa. Cass says this is dangerous. Parents might be able to keep these away from children, but parents are not always there to care for kids to ensure they're getting kid-friendly Skittles and not the adulty ones. Exactly. That is absolutely right. It looks way too similar. Maybe if they use some type of different design or made like the bag silver or something, like how most cannabis items that I've seen, they have like a different style of packaging, but this packaging looks exactly like the shareable version of these candies. And let me go back to the screen. Actually, we have this. They have like this little corner that says THC. There's like a glare even on the computer screen of it. So you can't even see that it says THC all the way. And definitely if some kids see this, they don't know what a THC is. They have no idea. So yeah, that's a little bit dangerous. It's on sale though. It's on sale. Oh man. Where are we at? Where are we at here? Tiny D says, what made them think they wouldn't get sued for using such a popular brand? I have no idea. Sounds like something a young person just started up and had said, hey, I'm going to start selling these weed products and I'm not going to get in trouble. Starbucks is not looking at me. Or they maybe didn't even know about freaking trademark, because remember, this person is a sole proprietorship doing business as, not a good business entity. That is not a good business entity if you are serious about doing business. You need your LLC. I don't know if THC companies can be LLCs in California, but you can still be a corporation, okay? To protect you legally. And maybe you can't. Like I said, I'm not in the THC industry, so I don't know what entities you can use for that, but I'm pretty sure you should be able to have a bigger entity and not be a sole proprietorship, because you wouldn't be able to erase that liability, or maybe they don't want you to erase the liability. Like lawyers and doctors, we can't be LLCs, so maybe it's the same situation. And I'm not all the way educated on that to tell you guys exactly what it is. Tamara Marie says, maybe they actually got bad legal advice. Potentially. There are some people out there just saying that they're a lawyer, or maybe they went on LegalZoom. Don't go on LegalZoom. Let me not say that. But yeah, you want to go to an actual lawyer. Judy says, maybe they thought they were small enough to slip. Yeah, slip under the radar. Yeah, that's a potential. That is definitely a potential. Tiny D says, guess so. Rose says, I'd be less concerned about kids and more about teens getting it and intentionally bring it to school, knowing that adults won't notice. Then imagine other teens being pranked with them. That is very dangerous. I didn't even think about that. Thank you for putting that out there, because that is another thing that can happen. They're going to be the ones more like now, their teens are going to be the ones more likely to bring it to school on purpose. But imagine an elementary kid brings it to school on accident. I've seen a post like that before where like a little girl brought little tequila shots to school. So imagine even if elementary kids got a hand of it and took it to school too. So yeah, anybody under 18 or whatever the legal age is to use cannabis, yeah, not a good idea. So haven't thought about that. Lewis says, fun fact, Starburst used to be called Opal Fruits in the UK. I did not know that. Did not know that at all. Judy, you got this as all profits. That's more than a slap on the wrist. Yes. And plus $2 million per unit. Whew. He's gonna be paying that for the rest of his life. He won't be making no more candy. Tanya D says, I'm sure they do. Kids have been having pill parties for years, throwing a bunch of pills in a bowl and calling them Skittles because they were pills of various colors. That, I've never done that, but I have heard of that, and that's very dangerous. More dangerous, I don't know if it's more dangerous than these gummies, but definitely dangerous. Desby says, sounds like bankruptcy. We covered that. Tiny D says, cool, Lewis. I love a good trivia info. Yeah, exactly. Judy says to Tanya, I'm now the mother of a teenager. You think that's where my mind would go, but no. Jesus Christ. Tamara Marie says, sounds like bad advice. Sounds like bad advice to me too. Judy says, I don't take cannabis because I'm on pain meds for my arthritis. it would be a very bad mix for me personally. That makes sense. Very much so makes sense. Sue Magic says, just think of some LO or some little or some LOL giving them out at someone giving it out at Halloween. Not safe. Not safe at all. Those would be very expensive Halloween favors though. But yeah, I hope they're not individually wrapped, because that can make it even more dangerous, right? Lewis says, I can't help but laugh. This is kind of hilarious. How could anyone think this was okay? Completely copied their logo, right? Completely copied their trade dress, all of the things. Dasby says there are a lot of small, I don't know what that says. Desby says, oh, here we go. Small edible companies doing this though, like thousands. I agree with you there. And I think that's why they sued all of these people, because maybe these ones were the most popular ones and they wanted to make an example out of them. That's why they're charging him $2 million per unit. That's a lot of money. They're making an example out of them. And I hope people in the cannabis industry that are using famous trademarks are paying attention to this. We have Marianne Williams. Thank you so much for the super sticker. We can't see the little guy over here, but it's a little pair doing like a little bow thing with a sweatband on. It's so cute. Thank you so much for supporting the channel. You're a member and you're giving out super stickers. Thank you so much. We appreciate it over here at the BRI-HIVE. Then we got the peeps talking to each other. I'm gonna try to get through a couple of more of the super chats, or not the super chats, of the chats. And then we're going to get on to Oprah Winfrey and see what she has going on over there. I wish they would show us the little things. Oh, yeah, and it says thank you, too. So, yeah, thank you, Marianne. Thank you as well. Tanya D says, it's on sale. Lisa McKinnon says, Judy, that was very wise. I would be terrible to mix those meds. Yes. Tiny D says, thank you for the support to Marianne. Thank you. Lisa McKinnon says, Tanya, very true. Did you ever hear of the LSD dots? I have never heard of that. Okay, Tiny D says, I have, Lisa, the world is a scary place. Lisa, Judy, so true. Okay, the combos. All right. Desv says, this might sound foul, but imagine seeing a bunch of elementary kids zooted off some spiked Skittles. That would be horrible. And they will all probably be in the hospital trying to get them to calm down, because I have done too many edibles before, and it was not a good experience. And I was a fully grown adult when I did it. So I can only imagine kids doing that and how they would feel. Because I was scared. When that happened to me. So hopefully that does not happen. Lisa McKinnon says, Ro, do you think the candy company foresaw teens doing that? Probably. Okay, Lewis says, I thought the Audi versus M&S Caterpillar thing was crazy, but this is on another level. Yeah, good case to start with, guys. Good vote. And we have here for the truth saying thank you to Tanya. Yes, good vote on the case. Yeah, this one was a very interesting one. Like I said, there are still some people who are sued under this case, so it can very well go to trial against those people. Other people, they have defaulted, they haven't responded in the case, so boom, they're getting in trouble. I can look and see what the court ordered against them in those judgments, but we're not going to do it today. Maybe I'll tweet about it if I have time. Guys, I'd be so busy that when I have time, I just ignore everything because I don't want to do anything. But maybe I'll look at the judgment and then tweet about it. Well, I gotta buy it, so we'll see. We'll see if we get it. But if I do look at them, I will tweet it for you guys to see what the judgment was for those ones. But yeah, that is the Skittle case. What do you guys think about that? I know we went through a lot of comments. It was a little foul that they literally copied the full-on trade dress, and not like just the word, and they're not like comparing it to Skittles, which could be a defense, but they're actually using it as like, these are weed Skittles. Come buy some. Because Skittles decided that they wanted you to also use cannabis. Maybe the kids too. That looks bad on Skittles or Wrigley or whoever you want to call them, the company that owns them. That looks bad on them. They don't want that out there. They don't want to be liable for that. Someone said earlier in the chat that they're already being sued for being toxic. So imagine them selling THC candies on top of that, okay? I really want to look into the fact of if you cannot be a corporation or an LLC if you sell cannabis. I want to look into that. But next case, we have Oprah Winfrey. Oprah Winfrey suing for another trademark case. This one is a little bit longer. So we're probably going to pop around in this one. It's a couple pages of the actual trademark registrations and things, but we're not going to read every word. Like I said, I don't be having time to go through these before I get on live stream. So I'm live reacting with you guys. So let's check it out. Oprah Winfrey in a trademark lawsuit. That just shocked me so much, which made me want to cover the case. So we have Harpo Inc., which is Oprah's company, suing Kelly Carter Jackson, Leah Wright Ruger. I'm going to mess that up today. Ruger and Roulette Production LLC. It's a complaint for demands for a jury trial. And hopping into it, an introduction and summary of the relief requested. Plaintiff Harpo is a privately held entertainment media company founded by Miss Oprah Winfrey. Miss Oprah is one of the most well-known media personalities and entrepreneurs in America and beyond. Her fame is so extensive that she is instantly recognized by her name Oprah alone. Harpo is Oprah spelled backwards. I did not notice that. Harpo is Oprah spelled backwards. Harpo is the owner of the Oprah and O family trademarks. Over the past 35 years, let's see, the Oprah brand has become well known and famous. Without authorization, defendant Jackson and Ruger commenced use of the confusingly similar and coined Oprahdemics trademark in connection with a podcast series and other entertainment and media content, including live events. Oh, they're doing live events? I didn't know that part. Defendants used the trademark Oprahdemics and the following O logo. Oh, this is bad. In connection with their service and content on various platforms and live events. Okay, I have to make this bigger. I'm telling you guys, I do not be looking at this stuff all the way. Like, I just get the content. I go get the complaint. Sometimes I have a chance to read like the first couple of paragraphs, but for the most part, I do not look at it all the way. But look at this. Let me make this bigger so you can come look at this. We have the O, which Oprah uses, O. And then this is like a little drawing. Can you guys see the little drawing back here of like the hands holding out? Oprah is pictured so many times doing that. Like, even though you covered her face with this flower and the microphone and all of the things, people are going to see that as Oprah. Like, people are going to see that as Oprah. This is bad. This is really, really bad for them. Okay. So now that we got that out of the way, that this is not going to go well for them, let's see what else the complaint has to say. The first season of Oprahdemic podcast series culminated in a live show at the Tribeca Film Festival on June 15, 2022 at the SVA Theater located in New York. Following this event, defendant Jackson and Ruger hosted another event on Instagram Live on July 12, 2022. This is very, very recent. This is last month. They're calling them out for stuff that they did last month and 2 months ago. Okay. Upon information and belief, defendant Roulette Productions owns the domain name registration for Oprahdemics.com, on which the website for the Oprahdemics brand appears on behalf of defendant Jackson and Ruger. Harpo has commenced this action, the sole purpose of which is to protect its trademark rights. Harpo does not seek monetary damages or profits available under applicable law from defendants. Oh, yeah, they don't seek monetary damages. Oh, okay. for defendants' wrongful acts or building of media and entertainment brand by capitalizing on the goodwill of Oprah and O family trademarks. Nor does Harpo seek to prohibit defendants from airing a podcast series on their chosen topic. However, Harpo submits that the court should enjoin defendants from wrongly creating a new brand incorporating Harpo's trademark and making trademark use, which is dilutive of and constitutes misuse of Harpo's, Oprah and O family of trademarks and explicitly misleads consumers as to the source or sponsorship of defendants' branded offerings. So they're not even asking for money. They just want them to stop using it, which is very, very generous. Very generous. They don't want the money from them. They don't want to put their podcast out of business. Cough, cough, Wrigley. Put that man out of business. But they just want them to stop. They don't want the money. Okay, so they're not as aggressive as Wrigley. Whew. Okay, so we're going to skip the parties and jurisdiction. Do we want to go over the trademarks? I'm just seeing how long all this stuff is. Ooh, that's a lot. Okay, yeah. We'll go through the trademarks. Okay, let's see. Let's go. The Oprah brand rose in prominence in earnest in 1986. I'm having a hard time reading today. With the premiere of the Oprah Winfrey Show, over the decades, Harpo and or its predecessors and interests have and continue to market and offer branded entertainment service, media services, educational services, and related goods and services under the Oprah and O trademarks. Harpo also licenses the Oprah and O family of trademarks after careful consideration and vetting to make sure that the products and services meet the brand standard. While the final episode of the Oprah Winfrey Show aired on television in 2011, after 25 successful seasons, the Oprah brand continues to grow and has been associated with other television shows, the OWN network, magazines, a podcast series, a book club, films, social media content, live events in New York City and around the country, and various other forms of media and entertainment goods and services. Similarly, variations of the O logo, which is distinctive of Harpo, have been used and are associated with a wide variety of media content offered by Harpo and its licensees. By way of example, only Oprah's Book Club uses the O logo on a popular Twitter account. And as you can see, the O is there. So, over the years, New York City has a major market for the Oprah Winfrey Show and continues to be a high-profile center of consumption of entertainment and educational content branded under and or affiliated with Oprah and the O family of marks. For example, on or about February 2019, Miss Winfrey hosted Oprah's Super Soul Conversations, a live event at the PlayStation Theater in New York. The live event is an extension of the podcast series Super Soul Sunday. So basically, the reason why they're bringing this is because they do similar media content and they don't want this other company competing with them. They don't necessarily want them to stop talking about Oprah on their podcast, but they definitely don't want them using similar trademarks, making it seem like Oprah is somehow affiliated with their podcast. Now, they also gave information about how they do license out the name, which we talked about in the Nicki Minaj case that we covered last week. You can license it out. You have to ask for permission for it, and that at least gives Oprah the ability to say, hey, you know what? I don't really like the content. Hey, you know what? It doesn't really represent my brand. And so they can say no to actually using the name. And so that's the reason why they're filing this lawsuit. They're okay with using their money to defend their trademark. I wonder if they sent them a cease and desist letter. I haven't seen that yet. So let's see what else it has to say. Simply being associated with Oprah brand has, in many cases, led to an exponential increase in the products and services of sales. This has been colloquially referred to as the Oprah effect or the O factor, as was examined in the 2009 documentary on CNBC, titled The Oprah Effect. Harpo is the owner of a family of Oprah and trademarks, including but not limited to common law marks and the following marks registered with the United States Patent and Trademark Office. So they go on to list all of their trademarks. Class 41, entertainment 42, more internet stuff. This little Oprah trademark here. Oh, let me make it bigger so you guys can see it. This little Oprah trademark and script font. Let's see what else they got. Oprah.com. They have Oprah Winfrey Show, Oprah's Book Club, Oprah's Favorite Things. Oprah's Favorite Things again, Oprah's Life Class, Oprah's Next Chapter, Oprah's Super Soul Conversations, which is her podcast, Oprah's The Life You Want, Oprah's Media Group, Oprah Winfrey Network, Oprah Winfrey Network again, Oprah Winfrey Presents Belief, Oprah Winfrey Scholars Program, which is this little, similar to what they're producing their content under, and another O. Go ahead and state that they are active trademarks. In addition to the federally registered marks, as well as the large portfolio of trademarks around the globe, Harpo owns common law rights to each of the trademarks identified above. Let's see. Okay, they use it throughout the OprahWinfrey.com, and boom, they're a famous trademark, right? So, looking at some of the chats. Okay, so going into the Oprahdemics brand, they're going to go ahead and let us know about them, what they do, how they're infringing on them. Upon information and belief, defendants Jackson and Ruger began co-hosting a podcast series under Oprahdemics in or about spring of 2022. So again, like I said, this is a really recent case. Like they just started and Oprah's like, no, we're going to nip that in the butt as soon as it starts. As soon as they found out about it, basically they are filing their lawsuit. The trailer aired on or about March 23rd, 2022, and the first episode aired on or about March 30, 2022. Upon information and belief, the Oprahdemics podcast series aired about 15 episodes in the first season, culminating with a live event being recorded in front of a live audience at the Tribeca Film Festival in New York on June 15, 2022. Upon information and belief, tickets were sold to the live Oprahdemics event in New York, and the event was promoted on various websites and or social media. For example, they have this little promotion to go to the live Tribeca show. They also have this social media post here by the Radiotopia. Upon information and belief, defendant Jackson and Ruger promoted the Oprahdemics podcast series, the live event, and brand in general on Brian Lehrer's show, which aired on WNYC New York Public Radio on July 7, 2022. Defendant Jackson promoted the Oprahdemic podcast series on Good Morning America. Okay, so they are getting recognized. They are getting recognized for this podcast on May 28th. Defendant Jackson and Ruger also hosted an Oprahdemics Season 1 graduation event on Instagram Live July 12, 2022. Defendants Jackson and Ruger actively participate in or control the brand's website, which is located at Oprahdemics.com, a domain registered by defendant Roulette under the name Roulette Production on December 17, 2021. So this had already been in action. Okay. And then also that graduation special, I feel like that also relates to Oprah because she's always doing some type of charity stuff, right? Defendant Jackson and Ruger operate Twitter account Oprahdemics and the Instagram account Oprahdemics, promote the Oprahdemics brand, the Oprahdemics podcast series, and the associated events. Oprahdemics, that's such a weird word. Brand website, the brand's Twitter account, and the brand's Instagram account all feature the Oprahdemics logo. Here we go. Oh, I didn't know they were other Black girls. So yeah, they're putting themselves on there. Oprahdemics, as you can see, all of their little promotion. Upon information and belief, the Oprahdemics O logo was also used and prominently featured at the live recording. So you see the big O in the background. They're using that same logo to kind of show that I can see how they can say that it makes it look like that Oprah is sponsoring this or that she's related to it or affiliated with it. Defendants are planning to release a second season of Oprahdemics podcast series in the fall of 2022. I wonder who they're getting their legal advice from. Okay. Because like that logo in the name, like did they talk to a trademark attorney? Ay. Okay. Defendant's use of Oprahdemics trademark on Oprahdemics O logo is not authorized by Harpo and was undertaken in bad faith by virtue of their intent to exploit the goodwill and representation of Harpo's trademarks and create confusion as to the source, sponsorship, and or affiliation of the service or goods provided under Oprahdemics trademark and Oprahdemics O logo. Upon information and belief, defendants Jackson and Ruger have also acted in bad faith by attempting to capitalize on the goodwill and representation of Harpo's trademarks to raise their own personal and professional brands. Defendants' unauthorized use of the Oprahdemics trademark has diluted and continues to dilute the distinctive quality of the famous Oprah trademark. The activities of defendant complained herein, which include the use of the Oprahdemics trademark and Oprahdemics O logo without Harpo's consent, are also likely to cause confusion and mistake in the minds of the consuming public and are explicitly misleading and in particular tend to and do falsely create impression that Oprahdemics brand and the Oprahdemics O logo are authorized, sponsored, or approved by Harpo when in fact they are not. Despite Harpo's request, defendants through counsel have refused. So they have sent them a cease and desist letter. Have refused to transition away from the dilutive and confusingly similar Oprahdemics brand and Oprahdemic O logo. So someone's supporting them in this decision. They sued for federal trademark dilution, so making the trademark not as valuable as it is if they were not using it. They're suing for trademark infringement, basically copying their trademark, unfair competition, and the use of false designation of origin. They also are suing for federal cyber squatting. So they're holding on to the Oprahdemics website, which they're calling cyber squatting. Good one. Common law trademark infringement. They're also suing for common law unfair competition, New York State law for dilution. And what they're asking for is the court to enter a judgment declaring that defendants' use of Oprahdemics mark constitute dilution by blurring in violation of the Trademark Act. Harpo's Oprah O mark have been and continue to be infringed by defendants' violation of the Trademark Act again. Probably for this one is for false designation. Which one is that? I don't remember off the top of my head. But basically, everything that they're suing for. Defendants, Oprahdemic constitute unfair competition. Defendant had a bad faith intent to profit from Oprah mark. Defendant used the Oprahdemics.com constitute cyber squatting. Defendant's use of Oprahdemics mark constitute trademark infringement and unfair competition under New York common law. Defendant's use of Oprahdemic mark constitute dilution by blurring in violation of New York general business law. An order prohibiting and permanently enjoining defendants, any officers, agents, subsidiaries, servants, partners, employees, attorneys, and all others active in concert, participation with them from using Oprah and the O marks, any marks that are confusingly similar using the domain Oprahdemics.com, any social media handles, requiring defendants, their officers, agents, subsidiaries, servants, partners, employees, basically to stop using it and to tell them to stop using the online thing. And they also request any other things that the court deems just and necessary. So they're not asking for any money. How do you guys feel about that? Do you think that they should be asking for money? Do you think that this is serious enough that they should be asking for money? Or do you just think it's not infringement? I'm going to go through some of the chats here. We got through everything quick today. Okay. Yeah, let me know what you guys think so far. I'm going to go through some of the chats. I'm going to try to catch some different ones. But I know most of the people that comment are mostly the same people, so it's all good. Yeah, so that is very, very similar in my opinion. Let me know what you guys think so far. Okay, we have Das Beat saying, let's be real. These are not people skilled in business or else they would be better. But they have an attorney telling them, hey, you don't have to stop using this. Crazy. Gloria Boss says, why would they be so blatant in stealing her image and trademark? Right. That's very similar. I think it reflects Oprah. I don't know if you guys think that, but I definitely do. Not that Karen says to Daz Beats that you're right. Tanya D says, even if I didn't know anything about business, I wouldn't want to do anything remotely related to Oprah that's asking for a lawsuit because they have to protect their trademark rights. Remotely, if it can partly, like maybe if they only did the Oprahdemics, but then when they add that logo in there, it's like, okay, what are you trying to do here? What are you trying to do here? Okay. Judy says, could they just be trying to earn as much money as possible before being found out? Possibly. And Oprah's not asking for any money, so they can continue to collect money here. Tanya D says, Oprah already knows she won't get any money. Yeah, especially if the podcast only has one season. They might be making enough money because of the association with Oprah. Like they were on Good Morning America, so they're getting some type of traction. Carrie Todd says, hey, Bri and everyone. Hello, welcome to the live stream. Judy says, can you imagine being so famous that the first letter in your name is a registered trademark? She's that famous for what she does, right? Lisa says hi to Carrie. Everyone's saying hi to Carrie. Dasby says that's pretty famous. Lisa McKinnon says, oh, Bri, that smooch warmed my heart. Oh, thank you. It's like a smooch. Oh, you forgot he came in here, huh? Judy says, no, that's Oprah. Oh, pick another font. Exactly. Lisa says, good grief, Oprah is a busy woman. Yes, she is. Erica Valerie says, whoops. Lisa McKinnon says, Judy, I can't imagine what that would be like, but you can be sure I'd be as protective of my name as Oprah is. Yes, you have to defend your trademark or you lose your trademark. So they have to be that defensive when you're coming anywhere close to the name that they're using. And Oprah is not a common name. A lot of people associate Oprah with actually Oprah Winfrey. So yeah, Oprahdemics, it sounds similar to something that Oprah would do because she created a school. She does a lot of charity stuff. So I'm not surprised that she's going after them for this. And she's in media. Maybe if they were like selling paper towels, she wouldn't go after them, but you're in media, you're doing a podcast, right? Judy says, if this was a way to honor Oprah, there's better ways of doing it. That is true. Tanya D says, I guess they are young girls, so she's not going in on them. Yeah, young Black girls. Maybe she wants them to still be entrepreneurial, but pick a different name. I don't see anything wrong. I don't see anything wrong with that, right? Lisa says, Tanya, maybe that they won't be made an example of like the candy company. Yeah, exactly. I think she wants them, or her companies want them to still thrive. They've already got the traction from the name. They just don't want them to continue to thrive. And if they want to use the name, call Oprah, license it from her, and send her a check to use her name. Makes sense. That's what she should be doing as a trademark owner. Sabrina says, quick pop in to say hi. I'll be part of the rewatch crew tomorrow. Looks like an interesting suit. Well, welcome in. Thank you for saying hi. Can't wait to see your comment on the replay. Tanya D says they won't as long as they change their ways. Seems like they're trying to be messy though. Yeah, if their lawyer, whoever's telling them to stick with it, go away from it. Because if she starts to sue you for money, there's no way you're going to be able to keep up with this, okay? Tiny D says we already read that one. Lisa McKinney says, I agree, Bri. Who on earth was their lawyer and where on earth did they go to school? Just let it go. Even if you don't think it's similar, so many of the things that she's doing is similar. So just let it go. Let it go. Sabrina says, good to see you, Titania. Lisa says, hello, Sabrina. It's pretty interesting. You might not be able to pop out. Yeah, the Skittles case is great. Oprah case is great. We covered some good trademark cases today. Tiny D says, it's definitely infringement. Not that Karen says, I would not want Oprah mad at me. Me neither. Me neither. Tiny D says, hello to Z. Welcome back in, Z Seltzer. PNK Faith says it seems like infringement, but sweet that they aren't asking for money. That is true. They need it, and it seems like they're just like, please stop. And I think that's a good way to go about it, but they might have to change what they're asking for and ask for money if they're going to keep being told no. That may encourage them to let go of the name, right? Gloria Boss says, why would the podcast companies suggest a different name? How did it get past each set of lawyers? Their lawyers just found that it was not similar enough. And even with Oprah's company sending them a cease and desist letter, they're still finding that they're not infringing. I would personally advise my client against this because Oprah is such a famous trademark. Maybe if it was like a startup company that didn't really do much and was in a different area of products or services to them, maybe, but when it's registered, when it's super similar, trademark attorneys or trademark examiners are very strict on stuff like this, especially with famous trademarks. And when everybody knows this person and everybody knows that they do similar type of services, it's not a good look for you. But whoever their lawyer is telling them to keep it up. They can keep doing it. Bad advice, in my opinion. Love Eddie Farmhouse says she's worked hard for her brand and the intent to profit off of her success seems obvious. I agree with that. She says, why wouldn't they? Gloria said, why wouldn't the podcast company suggest a different name? Their lawyer, I don't know what's going on with their lawyer. I really don't. Dallas B says, if they could figure out a deal to license the name from Oprah, that would be a huge deal and a very significant business arrangement. I doubt Oprah does that, though. She does license her name out, though. So they could have done that and maybe it would have been approved. But now that they've gone beyond her, or maybe she's trying to get them to retract and then license from her. I don't know exactly what her tactic is behind it, but they could license the name from her. And that would avoid this whole lawsuit. Pay her a percentage and keep it moving, right? Jane says, can you imagine getting an order from Oprah's lawyer and having the ego to say no? Yeah, they did. And that's going to make them more famous. It's going to make them more famous. Well, people that pay attention to trademark law are probably going to go look, see what they're talking about, make analysis on it, talk about it like we're talking about it. So a PR move, maybe, to say, oh, this big company is suing us and we're just a little company. Help us, save us, maybe. Love Eddie Farmhouse says, hey Bri, awesome to finally catch your stream. Great content, great vibes. Thank you. Welcome to the live stream. Love to have you here. And for those of you that are watching live or on the replay, if you have not hit the like button yet, go ahead and hit the thumbs up button. Help us out in the algorithm. We can have more friends and more chats like we're doing right now. Francisca Cruz Aranciba, I hope I said that right, says, hi, new here. Cheers from Chile. And yes, so famous that the only thing you need is a letter and the hands. Exactly. You know that's Oprah. You know that's Oprah. And then the little hair. You can see the hair in the background as well. But welcome to the live stream. Nice to have you here. Lisa says, Jane, no, to give them a letter and then saying no. Carrie Todd says, kind of disrespectful to use the O. It's all disrespectful. It looks like Oprah, like maybe not the best quality of what Oprah would pay for, but it definitely looks like Oprah. And they put that on the second page of the complaint, didn't they? Let me see. Second page of the complaint. They put it out there. It's Oprah. And like even the little belt, oh my gosh, even the little belt on the outfit, we can probably find this picture on the internet of what they use as inspiration. We could probably find that. And then even back here, it's like I could see her hair back here. Like it looks like they put a picture of Oprah in drawing onto this. Then they put flowers over her face. That's what it looks like to me. And then like even this drawing, let me not get into their logo. But yeah, it looks very similar. Yeah, let's see what we have going on here. Make sure you guys hit the like button. We got 73 likes, which is good. But if you haven't hit the like button yet, they can help us out even more. Okay, guys, that's all I have for today. I have a busy night to get to. I need to go to the gym. I need to cook dinner. I need to still work on some of my cases that I didn't get to today. So that is all for the live stream today. We didn't go 2 hours, an hour and a half, not bad, but we didn't go 2 hours. So thank you guys for keeping the chat happy. Thank you guys for watching live. I believe that Rob from Law and Lumber is live right now as well, talking about the golf with one of the golfers suing for like $750 million. So if you guys want to, or you guys should go over and support Rob's channel after this. If you're still looking for some live streams to watch, I'm sure he will definitely appreciate it. If you go over there, make sure to drop some sunflowers and bees and crowns in his chat to let him know that you guys came over from me. Like I said, thank you for watching the live stream, and I will see you on Thursday and see what else craziness comes out for the rest of this week. I will see you later.